Hello YouTube, I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. I have a question here from YouTube user 3 Kings 144K. And 3 Kings asked us, "Hey Vince, I really need help understanding why my lawyer only signed a pre-litigation contract with me. I just received my right to sue letter, and now my firm wants to pressure the company to settle. What should my next steps be?" Okay. So, a couple of different reasons why a firm might do a pre-litigation only retainer. I guess the simplest one is, I assume you went through the Equal Employment Opportunity Commission potentially. That might be what you're discussing as the pre-litigation. If they're doing the EEOC only for you, they're probably trying to make sure everything that crops up in terms of the evidence in the EEOC is solid before they go ahead and make you an offer to bring the litigation for you. That's one thing that could be going on. Now, the next thing that could be going on is, and when you say pre-litigation, I don't know if they're just talking settlement. I don't know if they're handling the EEOC for you. Like we don't know exactly what they're doing. Something before litigation. So in my mind, that means something before federal litigation, although it could be state court litigation or even arbitration. We don't know. So that could be just negotiation. That could be filing with an agency. That could be filing with the EEOC, which is an agency. Like, who knows? So, one, they might be running the EEOC, get free discovery, make sure the claim makes sense for them, because they're going to put a lot of money and time and effort into that, and that makes sense. They're just being a little bit safe. 2, sometimes claims can be valuable via settlement, but would not necessarily do well in litigation. You might know something about a claim. You might know something will turn up in discovery. Well, it doesn't kill the case. It doesn't make the case frivolous or fraudulent, but it introduces a lot of risk into the case. So you would say to the client, listen, smart money settles this case. Like a lot of cases, all back to trial. This is not a great one to go to trial. And we don't really do this, but firms do, and it's not a foolish thing to do. You might say, listen, I think I can get you $100,000 on this case in settlement. If this case goes to trial, I believe you're getting nothing. So they might just do a settlement-only retainer or an EEOC pre-litigation retainer. That certainly happens. Also not crazy. If they sincerely believe that, they're not just flipping your case, and you think they make a point and you're on the same page, I'm all for it. That's great. That's a good strategy. If that's true about the case, that's fine, right? Now, third reason could be the firm you're working with doesn't have a trial team. It's not the end of the world. It doesn't make them a bad firm. It does mean if defense counsel knows they don't have a trial team, you might not get as much in settlement on your case because defense counsel might know they're not going to go to trial. There's firms out there that are known by defense counsel to not go forward. Not great, right? There's firms who just do settlement letters. So a lot of firms on the defense side ignore them. There's firms who just do settlement negotiations and don't have a trial team and can't go forward. A lot of defense firms tend to ignore the claims they bring because we'll see if this claimant gets a real attorney to go forward. What's our risk actually? All possible. Doesn't mean that, again, they might be helping a lot of people. They might be getting people settlements. My concern is, are they maximizing the settlements? But they're certainly probably helping a volume of people that path. So they're not bad people. They're not necessarily bad attorneys. If I was setting my family up, a family member for a case, I would not be sending that family member up with a firm that doesn't have a trial team. I'll tell you that. But it doesn't mean they're bad. And the last possible reason why you have a pre-litigation only settlement is sometimes there's firms that just flip cases. They're case flippers, right? So I give the common example. A lot of firms in this industry at 40%. 40% of what they win for you. So if a firm takes your case, says, hey, I'm going to get you a settlement of $20,000, sign here. Takes them all of 2 hours because your case is probably worth a lot more than $20,000. So defense counsel is thrilled to, cut that deal. They got you $20,000, but they're taking their 40%. So they're taking $8,000 of your $20,000. They just made $4,000 an hour. You see the business model for a case flipper. It's not a bad business model. The only bad thing about case flipping is if you're doing it to people who don't want their cases flipped, right? Like if you're going in and you believe this firm that you hired is going to fight the fight and max the value and, make smart decisions about risk and try to get you every dollar they can, and then they flip the case immediately for 20 grand and tell you better take it if you know it's good for you, that's not useful, right? If they're, on the other hand, clearly communicating, hey, seems like you want money fast. We can get you money fast. It's going to be a fraction of what you might have won, but like we can get you money fast. We're the firm for that. If that's what you want, we'll help you. If that's the communication and it's all up front like that, that's fine. If the client's happy, I'm happy. If the client tells you what they want and that's what they want, I applaud that firm for providing the results the client wants, right? Again, my issue is more like, hey, sign up with us. We're gonna move the heavens for you. We're gonna invest heavily, work this case to hell, push it forward aggressively. We're gonna get you every dime you're owed. We're gonna make you whole. Thanks for signing that retainer. Hey, I got you 20 grand. I know you just signed the retainer an hour ago, but I got you 20 grand. You better fucking take it. Better take it if you know it's good for it. Right? And firms will do this. And like, I'll drop your case right here, right now. Nobody will pick up your case if I drop it. They say this stuff. They say this stuff. And it applies undue pressure to claimants who've been through hell. I might not find another attorney. Oh my God, what's going on? Right? It's bad. It's bad. And it's not in keeping, in my mind, with the duty of loyalty we owe to our clients. I don't think it's ethical. It's perfectly ethical if you're like, hey, gonna get you a quick settlement, not gonna max the value. If you're disclosing and that's what the client wants, perfectly ethical. On the up and up. In fact, I would say you're providing a valuable service to people who want that service that a firm like mine wouldn't provide. We don't want to flip cases. It's not a good use of our time. The minimum value on claims, why? Why would I, right? Like, but if a firm is set up not to max value, not to take cases forward, not to push aggressively, but instead to cut a large volume of settlements, they can do just fine that way. And as long as their clients are aware that that's what they're getting, I see no problem with it. But that's the fourth reason that you might have a pre-litigation only retainer. The most common reason, again, is just the firm likes you, likes your claim, wants a little bit of free discovery to make sure they can like drop 20, 30, 40, 60, 80 grand into your case and hundreds of attorney hours. They just want a little reassurance. They want to make sure that first scuffle doesn't turn up anything too wild in terms of like, I don't know, basements in your closet type of thing, like it's all fun and games to walk into a discrimination case and then the defense counsel's like, yeah, so your guy kidnapped his two coworkers. Like, no, he didn't. No, that never happened. Here's the police report, dog. Oh. Your client pled guilty to the kidnapping. Well, Frank, thanks for letting me know. I'm not going to say much in response to this. I mean, obviously, you have your story and we have ours. But I will be having a conversation with my client. We'll get back to you, Frank. Thanks for the police report. And you go to your client, you're like, hey, leave some stuff out. You didn't want to tell me about the double kidnapping charge that you pled guilty to, in which you kidnapped your actual coworkers? You didn't think that was relevant? Right? Like that. Obviously, I'm being facetious here. And, this is a ridiculous hypothetical. But this kind of stuff does kind of happen. Like rarely, but sometimes claimants in this field don't want to give you the whole story. And then you get into the position statement on EEOC and you find out like, why were you bringing a machine gun to work? To show off? That's not. Take it to the range. Not work. Why? Right? And it's just, a damaging fact that you couldn't have foreseen. So sometimes firms will just want to see what they can find out at that first level before they extend the litigation offer. Now, here, Three Kings, I'll note, seems like the firm you're working with is trying to pressure the company to settle. That's fine. That's their job. They should be pressuring the company for you. Are they also pressuring you? And are they keeping an eye on your statute of limitations, which is 90 days from when you receive that right to sue letter, to get filed in federal court? Because if they're not, and if they're not willing to make you an offer for that litigation, you need to be talking to other firms. Because if this case doesn't settle, you're going to need representation to take the case on to federal court for you if the current firm you're working with doesn't intend to do so. So you need to have that conversation, keep an eye on that statute of limitations, and if they're saying, no, we're not going to litigate this for you, you need to be talking to other firms right now, because those other firms are going to want at least a month to get filed. Most of the time, right? Like, people do it in less time. Obviously, it can be done. But nobody's excited about a rush job to get filed in federal court with 36 hours notice, right? That is something you can do, but like all the associates who get assigned that are going to be a little mad. They're not going to sleep that night, right? Like, it's not ideal. So get out ahead of this. Be aware. I wish you luck, I wish you luck, Three Kings. I'm rooting for you. I hope they get you a great offer. If they don't get you a great offer, I hope they stand by you and take you to litigation, or that you find great counsel. I hope you win. I hope you're made whole. I hope the money can fill the hole in your soul, which we all know will never happen, but I'm rooting for you. All right. If this was helpful, like, subscribe, comment down below. Share our channel so it can grow. Take care.